Welcome to a courtroom where tension finally boils over. The hearing begins with a Nelson motion, a request to replace court-appointed counsel, and from the opening statement, it's obvious this won't be a simple disagreement over strategy. The defendant believes his lawyer has actively failed him, ignored critical evidence, and sided with the state. That conviction drives every argument he makes from this moment forward.
Yes, ma'am.
All right, sir, state your name.
Xavier Javar Stanley.
Mr. Stanley, what are you asking for today?
I'm asking to be appointed different counsel, Your Honor.
Okay, and what are your grounds?
My grounds is, Your Honor, Ms. McCarthy, she's very incompetent. I request to discharge the counsel appointed substitute. Keeping Ms. McCarthy on this case, Your Honor, it will result in ineffective assistance, Your Honor. She has not provided me adequate counsel whatsoever, Your Honor. I got a lot of grounds. Back in August of 2023, Ms. McCarthy told me that she reviewed the case, determined that I would never should have been charged with this robbery, first and foremost, Your Honor. She also met with me November 16th, November 17th, and November 20th of 2023, and told me that I should not enlist the facts in the motion to dismiss. I had the counsel at the jail pull that too as well, to where she told me not to enlist my facts in the motion to dismiss, Your Honor. Let's see. As well as the sworn statements on both cases, Your Honor, we got evidence to where the victims in both situations excluded me. We got one victim lying, giving two contradicting stories, Your Honor. Ms. McCarthy advised me that she would have these charges dismissed due to the police bribing witnesses to implicate me in this situation, Your Honor. That has not been done. She said it doesn't matter the facts because you believe every defendant is guilty until proven innocent. Her words, I got that too right here for you. It's in a letter, if I may approach.
Nelson hearings aren't emotional reviews, they're performance evaluations. The judge isn't here to decide whether the defendant trusts or likes his attorney. She's focused on one question only: did counsel's conduct fall below professional standards? And that line matters, because frustration and ineffective assistance are not the same thing.
I highlighted for you, Your Honor. All you gotta do is read it.
Provide a copy to the state. Let the state look at it.
I got one for him too, Your Honor, if you need it.
Yeah, you need, if you're going, or if you're asking to accept that in the evidence, you can just let the.
Just highlight what she said. I wasn't done though, Your Honor. I can continue if I may.
Go ahead, let me see it there.
Judge, with the uniqueness of these claims, Your Honor, that I make, it consists of that letter in the paragraph that you finna read that's highlighted, Your Honor. And as you can recollect, when I was here December 19th for the motion to dismiss, Your Honor, she said absolutely nothing. She stood where she is now. She ain't defend me whatsoever. She said not one word, Your Honor. Me and Mr. Sullivan went back and forth like I was representing her in the courtroom, Your Honor. You know what I mean? More so, Your Honor, if you notice in the letter, on paragraph, she said, I cannot think of a defense that would be successful in trial. I don't need an attorney like that who's incompetent, who does not want to list the facts in her motion, pertinent to the release sought in the motion, Your Honor, does not open her mouth in court proceedings or fight for the defendant whatsoever, Your Honor. She does not, Your Honor. And that's a 4-year-old letter from somebody else. This is what she continues to tell the clients, Your Honor, about.
As the defendant recounts meetings, letters, and conversations, the court remains silent and attentive. Judges don't interrupt to correct every misstatement. They allow the narrative to unfold so the record is complete. But courtroom persuasion isn't about volume or passion. It's about what survives legal scrutiny once the facts are tested.
Ms. McCarthy was supposed to talk to the
record, what I just wrote was somebody from another to another.
Somebody's family mailed that to me, viral mail to the Bay County Jail, Your Honor. This is the same thing that she.
I'm not considering that.
It's cool.
That's what I was going to ask about.
I'm going to strike that from the record, and I'm not considering that, Mr. Stanley. What?
You throw it away. I don't even.
Just give it back to him. I'm not considering that. I'm not putting it in the file. That's a letter to somebody else.
Your Honor, if I may continue, you were supposed to talk.
I haven't heard anything yet, sir, but go ahead.
I'm telling you, you were supposed to talk to the investigators to interview this bribe witness that they used, the only witness that they used to try to implement me in the robbery. She didn't do that, Your Honor. I got the document with these different victims, Your Honor, where they gave 2 different sworn statements on the oath. She has done nothing to present that either to the prosecutor, Your Honor. It's in black and white, Your Honor. These are signed statements. These are sworn statements on the oath. Ms. McCarthy was supposed to get the photos to
When outside letters and documents are introduced, the judge draws a firm procedural line. Evidence must be relevant, properly authenticated, and tied to this case. A letter written for someone else, about someone else, carries no legal weight here. That's not silencing the defendant, it's enforcing rules designed to keep proceedings grounded in law.
I was supposed to go over the victim statement with her to provide let me see. Ms. McCarthy was supposed to go over the victim statement, which proved the perpetrator was a Hispanic and not me. She didn't do that, Your Honor. And this is all in my discovery. It's all sworn statements. And I've had this Ms. McCarthy since August, since May. It's been 8 months. And she's done absolutely nothing.
You testified that she had been to the jail to see you, is that correct?
She's been to see November 16th, November 17th, and November 20th. I had the case manager as well as classification pull that video. It's attorney-client.
She went to the jail all those days?
3 days. I'm
gonna let Ms. McCarthy respond at this time. Ms. McCarthy?
Your Honor, the reason that I went all those 3 days is because we were doing a motion to dismiss, and Mr. Stanley wasn't happy with it, and so I kept coming back with it until he decided to sign it.
Because you told me not to put the motion to dismiss the facts.
I'm striking all that. Let her talk. If you need to say anything else, I'll allow you. Don't say anything else while she's talking.
The motion to dismiss was the motion to dismiss. It stated all the facts.
The dynamic shifts when defense counsel finally speaks. Her response is calm, structured, and precise. Multiple jail visits. A prepared motion to dismiss. A deliberate decision not to argue when a traverse already resolved the issue. This is legal work without theatrics, deliberate, technical, and often misunderstood by clients expecting visible confrontation.
Pertinent to dismissing the case. The reason that I didn't argue when we got to court is because a traverse was filed and there was nothing else to argue about. And that's where we are. We're ready to go to trial.
All right. Mr. Stanley, I haven't heard anything that Ms. McCarthy has done that would that has not been in your best interest or in preparing for your case. If the state filed a traverse, there's nothing to argue about. No, that's it. I've ruled. I'm going to deny your motion. We need to set him for trial.
I believe it's set for trial.
How are you denying? I'm telling you, she's done absolutely nothing, Your Honor.
I just denied it. That concludes the hearing.
And I got a video in the county jail to where she said not to put the facts in my motion. I already had them pulled at the jailhouse.
They shouldn't be. Ms. McCarthy may need to look in that if they've got something. They're filming attorney-client.
She perjuring herself in your courtroom, sitting here lying.
That will conclude the hearing, sir. Are we already set for trial?
I believe we are.
All right, leave it on the trial docket. Don't say another word, sir. Go ahead and take him back in the back before he gets in trouble. Ms. McCarthy. Mr. Nix,
The judge's ruling is short because the legal question is clear. She isn't weighing personalities or emotions. She's assessing competence under the law. And based on the record, the standard required to remove appointed counsel simply isn't met. Once that ruling is issued, the matter is settled, regardless of lingering objections.
I'm well. All right, Mr. Nix, you're here today on your motion docket. You're representing yourself. Do you still wish to represent yourself?
Yes, sir.
Okay. And I don't know that you have anything pending. I think if you got the orders dismissing your motion to compel and dismissing your motion to dismiss.
Yes, I just got them.
Okay. All right. Is there anything else today that we need to discuss?
Yes, sir. Your Honor, I got a couple of issues. Your Honor, this is what I don't understand. In the discoveries, the affidavit is not filed. Okay. And in the affidavit that is filed, it's not in the discoveries. There's two different affidavits. I don't know which one to prepare my defense on.
Okay. Mr. Sullivan, you understand what he's talking about? I don't either.
The affidavit that's in the discoveries is not filed. They're not filed. There's nowhere. There's only one affidavit that's filed through the case history. And so the one that's in the discoveries are not filed. It's a totally different affidavit.
I got no idea what you're talking about.
Here, let me show you. Okay, this affidavit right here. This one right here is filed. See, Your Honor, it's got the numbers at the top, 223101.
The defendant's reaction immediately changes the atmosphere. Accusations of dishonesty, misconduct, and conspiracy don't advance his position, they undermine it. At this stage, the court's role shifts from evaluation to control, ensuring the proceeding doesn't spiral into disorder.
Discoveries, it's a totally different affidavit, totally different statements. It's not a case file copy. It's totally different.
What's filed in the court file is a complaint.
Sir?
They have a complaint.
Yes, sir. Yes, sir. And in the discovery, the complaint that's in the discovery is totally different. It's not a case file copy. It's not a duplicate. And this was not filed. It's a totally different probable cause.
Mr. Sullivan, got any idea if you want to present that? Show Mr. Sullivan first and then submit.
So the one that's filed is this one.
The affidavit that's in question, who's the defendant on that?
Sir?
Who's the defendant?
He only has page 2, Your Honor.
I wonder if that's where Ms. Weber is. If that's Ms. Weber's probable cause affidavit.
No, sir. I got hers. It's totally different. I got hers. I got hers as well. No, sir. It's totally different.
Yeah, I understand what he's pointing out, Your Honor. I don't know, I guess, what his argument is. I mean, if there's an affidavit that was sworn out but never filed, essentially, what is the effect of that affidavit? It really doesn't matter.
Let me see what he's talking about. And I agree. I mean, if he was arrested on an affidavit, I mean, there may be something to cross-examine someone on.
The next case introduces a different challenge entirely: confusion over affidavits, discovery materials, and what actually matters at trial. Self-representation amplifies these misunderstandings. The defendant assumes paperwork inconsistencies invalidate the case, while the court understands affidavits exist to justify arrest, not to prove guilt.
It's what it appears to me, Judge, is it was a copy-paste of the addresses, and then they went back the next day and changed the address to what I would assume is the proper address.
So they changed the whole probable cause. They changed everything on it. It didn't change the address. You changed everything on it. The whole probable cause.
The one that's filed was signed on the 26th, and this one's signed on the 27th.
Yes, sir. They're supposed to be duplicate copies.
Well, they're not duplicates because they were 2 different days.
Yeah.
Yeah.
Again, it's like that they filed it, realized that there was a typographical mistake, and went back and filed a new one.
Just not.
I mean, I don't know what you want me to do. I mean, you've got it. I mean, you've got it in discovery. So, I mean,
Yeah, but it's not filed, Your Honor. I mean, how can you use something
Yeah,
that's
sorry, I
not
didn't
filed?
know. Like before too.
Well,
I mean, it's
some-
not filed.
affidavit of complaint has been filed against you. The
Well,
judge.
yes, sir, but they're not using the one that's filed. They're using the one that's not filed.
But you're not.
Who's ever on the Zoom room, you need to mute your.
You see what I'm saying?
Don't have to go now at 1:30
It's
then?
not filed.
Okay.
What do you
This-
want me to? What do you want me to do? What do you want to do?
I just need to, I don't know which one we're gonna go by.
We're not,
Okay.
I don't go by the probable cause affidavit. That's just a way to get you arrested.
Well, that's what you got the probable cause to arrest me for, wasn't it?
I'm not.
You changed it.
What do you want me to do right now?
I want the affidavit that's not filed to be stricken, taken out. Go by the one that's filed.
This exchange highlights a classic self-representation trap. Defendants often fixate on documents that won't even be presented to a jury, while overlooking the evidence that will be testimony, video footage, and physical proof. Procedure feels abstract until it determines everything that follows.
Talking about Mr. Nix.
It's not filed. So how can you use something against
It's
me
not
that's
filed. How can I strike something that's not filed?
Well, how can they use something against me that's not filed?
Do you understand the argument, Mr. Sullivan?
yes and no. I don't think Mr. Nix understands that the complaint affidavit is not being used against him in the sense that he's claiming it is. The information is what charges him with the crime. The information is what I proceed forward on. The testimony of the officers is the evidence that I will be using to prove that crime. The affidavits are not admissible in trial. They will not be used in trial. They're not going to be used against him.
Sir, he's already used the affidavit against me. It's not
I
filed.
got no idea what you're talking about, Mr.
It's
Nix. I got
expression
no
here.
idea what, I can't strike something that's not in there. And even if I could, I mean, there's nothing to strike. I mean, the information just.
As frustration builds, the judge offers rare but direct guidance. Representing yourself isn't empowering when you don't understand the system. It exposes every misconception on the record. Judges cannot step into the role of counsel, and they will not halt proceedings to provide legal coaching.
Charge you with what the information says. They can amend the charges. They make a charging decision. So you can hand that back to him, but I got no idea. What else do you have today?
So it's about, it's about the sworn statement. Mr. Sutherland said he talked to the officers and there's no sworn statement on the body cam, right? And then you said that there's no technical statement, right?
Correct.
And then you said there was no sworn statement, not even an unsworn statement.
No, that's
Look, this is not stuff that needs to be held in front of the court, Mr. Nixon. That's the problem. You representing yourself. You got to absolutely digging yourself a deeper hole. Now, you have a right to be represented by an attorney. That's what you need to do. I represent yourself, but you're having conversations in front of me that you don't need to have in front of the court.
Yes, sir. Well,
Well,
I can't talk to him. I mean,
that's because you're representing yourself.
on the body cam, I need to see the body cams again.
How do we do that when he's pro se? Because if you had an attorney, your attorney.
I'd have to play it in open court, Judge. I can't provide.
I'm not sitting here in open court and watching it. That's not my job. I don't have the time to do that.
Yes, sir. Yes, sir.
That's your problem with representing yourself. You're going to have to figure out some way to get it
What
done.
I'm saying is, Your Honor,
Listen to me. That's up to you. If you had an attorney, they would take it out there and play it for you. You don't have an attorney.
No, sir, I don't.
That's up to you to
You
get.
give me a different attorney besides Joel McCarthy, I'll take a different attorney, but I'm not taking
We've
Joel
already been
McCarthy.
through that. Did you ask for another attorney?
Yes, sir.
The plea withdrawal argument shifts the courtroom into a more analytical frame. The focus turns to voluntariness, pressure, and whether the defendant truly grasped the stakes of trial versus the certainty of a plea. This isn't about regret, it's about whether the process itself was fundamentally unfair.
And I've already ruled on that.
I've been asked for another attorney.
So that's the same thing. I mean, if you have to figure out some way to review the body cam, that's up to you. I can't help you with that.
What I'm saying is, if there's no sworn statement, then not.
Listen, do you want Ms. McCarthy to represent you?
No.
She can take the video out there and let you see it.
Listen, Your Honor,
All right, let's go ahead and set it for trial.
with Mr. McCarthy, let me explain something, please, sir.
I think I've already heard that.
No, I don't think you've heard this. I had 5 witnesses subpoenaed for the suppression hearing. 5 witnesses. Okay, she had it with only 2 witnesses.
Okay. All right, let's go ahead and set this for trial. Let's set it for April 1st. At 8:30, we'll set it for a trial management February.
I believe he's currently set for the February 5th date, Your Honor.
All right, are you ready to go to trial then?
No, sir, I need to see this video. Also, I need to.
Is it one on the list?
What's that?
Is it on your list?
He's one that, depending on some of the elements, he may make it. He's kind of on the fence. So I'm fine leaving him on if you want. Or I'm fine moving him to April, either or.
Let's move it to April 1st at 8:30, and you just figure out some way the body cam. I can't help you with that. I'm not sitting here watching.
Okay, but while I'm here, I need the CAD logs from July the 20th.
You're gonna have to file a request.
Okay.
April 1st at 8:30, March 15th for trial management.
Your Honor, I was appointed on to represent Mr. Palmore on his motion to withdraw plea. I had the chance to speak with him by phone yesterday, and we had corresponded prior to that by letter. The burden in this case is on the defense. My question is how the court would like to proceed, whether I can proffer what I anticipate the argument is, or whether you would like to hear testimony from Mr. Palmore himself.
It didn't. I don't matter either.
I think that, however, the court did not go far enough in determining the voluntariness of his admission to the no contest plea to the charges based on that statement. I don't believe the one additional question was sufficient to cure any defect in finding that he understood the terms of his plea, whether it was in his best interest, and particularly the voluntariness of it. He had stated in his motion to withdraw that he was under pressure and was given approximately an hour to determine whether he would accept that plea. He was given some advice from Ms. Bennett that if he didn't take it, went to trial and lost, he would serve 40 years to life. So the sufficiency of the colloquy, I would say, is in question. The second major issue in terms of allowing him to withdraw his plea is that he was given the opportunity to speak with Ms. Bennett in the attorney-client rooms off in the courtroom. During that, Mr. Palmore requested an opportunity to know what his family wanted him to do. Ms. Bennett purportedly called his family, spoke either to his sister or his fiancee, Miss McDaniel, and then conveyed to Mr. Palmore that they said, if it's up to the judge, you need to take the deal. After he was sentenced and taken back to the jail, he was able to get a corrections officer to let him place a phone call to family members trying to be placed in segregation in anticipation of his transfer to the Department of Corrections, at which time he talked to his sister, Miss Whitney Dean, and she conveyed to him that she couldn't believe he took the deal, that he should have gone to trial, and that it wasn't that wasn't what he had they had told Miss Bennett to convey to him. Based on those two issues, and there are other issues that are on appeal, but based on those issues which are pertinent to the motion to withdraw a plea, I believe it'd be a manifest injustice if Mr. Palmore was not allowed to withdraw his plea at this time and proceed forward to trial on the underlying charge, to complete discovery that he alleges was not done in the 3 years the case was pending with his prior counsels, Mr. Middleton and Miss Bennett. And he understands that the cases that were consolidated could be revived if you allow him to withdraw his plea. We had hoped his sister would be here, but I've called her name numerous times and have not gotten a response.
Mr. Sullivan?
Your Honor, as far as what Mr. Palmore's family wanted him to do, I don't believe that that's relevant. It's ultimately the defendant's choice to go to trial, take a plea. The simple fact is that Mr. Palmore was picking a jury that morning. He was colloquied, as Mr. Meredith said. I believe that colloquy was sufficient. The choice that Mr. Palmore was faced with was the choice between going forward with picking a jury trial and facing an enhanced sentence as a habitual offender, which would have exposed him to a life in prison sentence, or taking the plea deal without the enhancement, which he ultimately chose, which was for 25 years. Faced with that option, he chose the lesser penalty of 25 years. There's been no showing that there's any valid reason to allow him to now go back and withdraw that plea.
I'm going to take it under. I'm sorry, Mr. Mayor.
Your Honor, the issue of whether he qualified as a habitual offender, that is another thing that the record is not clear when or if Ms. Bennett conveyed that to him about the habitual offender. I think that was brought up the morning of trial.
It was discussed prior to the morning of trial. I had held off filing the motion because Ms. Bennett had asked me to wait so she could continue to talk to her client about the plea deal. So I had held off filing the notice. I came to court the morning of trial with the notice in hand, and my understanding is that she took a copy of that back to the attorney visit room to go over that and show Mr. Palmore that I had it, I was ready to file it, and that if we were moving forward, I would be filing it.
And I would direct the court's attention to paragraph 5 of Mr. Palmore's pro se motion about the habitual offender situation. So if you would review that.
I'll take under advisement. Just one thing for the record, you indicated that Mr. Palmore only had 1 hour to decide the plea. It's my understanding, I may be wrong, and Mr. Sullivan, you can correct me. I know, Mr. Meredith, you weren't involved, but I was contacted on Friday afternoon to have a hearing Friday afternoon to allow Mr. Palmore to accept the plea. And I declined to open the courtroom back up for him to do that, and based on my message to Mr. Sullivan and Ms. Bennett, and I actually to Mr. Palmore through Ms. Bennett, was to wait till Monday morning and to see if he still wanted to take the plea. But it was my understanding that he wanted to take the plea on Friday, and I declined the opportunity to do that.
That is correct, Your Honor.
All right, anything else?
Paragraph 1 of his motion talks about his being misled by Ms. Bennett in terms of if the motion to suppress was not successful, he'd be taken to trial. So it wasn't until after that motion that there was any discussion or urgency by his counsel for him to accept any plea. Now, whether that happened Friday or Monday in the courtroom, I don't know.
Well, I think we had trial management on Friday, and then after
when my motion going to advisement, when I'm going to know when you're going to deny it, like when I'm going to know what's going on.
Whenever you get an order from me is when you'll find out. All right,
Okay,
that'll conclude today's hearing. Good luck to you, Mr. Powell.
How long is it going to take for you to
I got no idea. I just told you whenever I get to it. That'll conclude the hearing, sir. It won't take too long.
I conclude the hearing when I got to say something.
What do you want to say? Go ahead and say it.
I'm trying to figure out, like, when will my motion be ruled on? Like,
By the end of this extended docket, a clear pattern emerges. Whether it's conflict with counsel, procedural confusion, or second thoughts after a plea, every defendant confronts the same reality. Courts operate on rules, not narratives. Belief and frustration don't drive outcomes. The system listens, documents, rules, and moves forward.
Yes, sir. I'd say sometime within the next 10 days.
okay. All right.
That'll conclude today's hearing. Yes, sir. Good luck. I'm doing well. And Mr. Beecham, you're representing yourself. I think I've already found that you're competent. You understand at any point in time you can ask an attorney to be appointed to represent you?
Yes, sir.
Do you wish to continue to represent yourself?
Yes, sir.
Okay.
Well, for I have a preliminary hearing today, so that was the last motion. For adversary preliminary hearing. You set it off to today.
I don't see a motion for an adversarial hearing, sir.
Judge, and it's been denied. If you go back to December 4th, there was
You denied
a
it with
motion
another motion?
preliminary hearing. However, that's what it was styled.
Okay.
If you actually look at it, that's not.
Oh, in support of a declaratory
I
judgment?
orally made one in court on the last hearing, and you put me off to this date. I orally made one up under the rule. It was within the 30-day mark. I had been incarcerated 30 days without an adversary preliminary hearing. I motioned for one, cited the rule. I wasn't charged within 21 days of the charging document. So if anything, at the least, could I be released on my own recognizance, according to how the rule says. That was the day I thought we was having a hearing. I can cross-examine the witness and determine probable cause.
So,
So there hasn't been a motion filed.
I was an R1 made in court. I made it. I've been incarcerated for 30 days. It took you the time for filing within 21 days. You didn't meet it. And so I thought today I was going to have a probable cause determination for that hearing. I'm entitled to it by the rules.
I don't see that, and I don't recall a oral motion to do that. There was a 40 day rule, which we call a 40-day rule.
No, it wasn't about the 40-day rules. It was a adversary preliminary
you want
hearing.
to file, I think you can file that motion anytime. If you want to file a written motion, we can set it
For the adversary preliminary hearings, Your Honor, I had already made one in court. I thought that's what I was going to be.
I don't
here for
recall
today.
that, and I'm not having a hearing today, but if you want, I don't think you waive your right. And I think you can file, unless I'm incorrect. I think you can file if you want to file a written.
It's actually within the 30-day.
I'm not having a hearing today. I'll give you an opportunity if you want to file
Okay,
a written.
thank you, Your Honor, but can I be released on my own recognizance
Motion
according to what
denied.
the rules say?
Motion denied. But if you want to file a motion for preliminary hearing, I'll have that February 22nd. I don't believe there's a time period.
Adversary preliminary hearing, it was for 30 days, but if you're willing to take one in for the next, I'll file the
You
motion.
just file your motion for preliminary hearing, okay? And remember, you give the state, I'm assuming you're giving the state copies of all this you're filing.
Yes, sir.
Okay. All right, anything else today?
You want me to put it in writing? You said that's
Yeah.
it?
Yes, sir.
And what date was that?
February 23rd at 9 o'clock.
And that'll be the adversary preliminary
Yes,
hearing
sir.
for the
You
record.
file the motion.
Yes, sir. Thank you.